Thank you. Please be seated. Good morning. We're here on oral argument for the matter of Brumley v. Brumley, case CACV 170498. And these proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, counsel, we have read the briefs and have discussed this case in conference. And there being nothing further, counsel, you may proceed.
Thank you. Good morning, judges, and may it please the court. My name is Bruce Blumberg. I represent Rachel Brumley in this matter. She's the respondent appellant in this narrowed family court matter that was heard before Maricopa County Superior Court judge. We claim, judges, that the trial judge made erroneous findings and abused his discretion with respect to the narrowed issues of legal decision-making and parenting time. As you'll note, that the parties they didn't ignore each other in this matter. They made substantial agreements with respect to finances and credit prior to coming to the court for trial. It began, as you know, with an order of protection filed by mother, respondent, alleging certain acts of domestic violence against father, which led father to file the petition for dissolution in this matter. The hearing before the commissioner regarding the order of protection ended with the commissioner saying, "I must keep these parties apart or someone's going to get killed." He actually terminated listening to the recording because he had simply heard enough. While petitioner appellee father complained to the commissioner that he hadn't perpetrated these acts, or he had, but in fact they were milder than what it might appear on the record, the commissioner did not change his ruling.
And counsel,
yes,
at that time, at the time of the events that led up to the request for order of protection, the child common to the parties had not been born. Is that correct?
With respect to, let's see,
JB.
Yeah, I know. Say it again.
The child common to the two.
The child in common,
initials JB.
Right. And I'm not recalling exactly when it was filed and when the child was born, but we know the events, that there were three particular events that led up to the filing. And one, as we know, was when mother had placed her ring down on the bed stand. She was tired of father gratuitously watching porn. Apparently he admitted later to Barb Kiffmeyer that he couldn't stop. And he sat down beside her with yelling and screaming invectives at her and placed his hand on her belly. Now, I don't recall how far along she was, so the timing in my head, the baby hadn't been born for that act in particular. And I don't recall whether or not the baby had been born with respect to the one on petitioner's birthday. But if I might...
Well, the one in July where they went camping, that, according to Mr. Brumley, they had this camping trip, which was going to be the last trip before the child was born, and the child was born at the end of July, so the child was not born at that time.
Right.
Either. And then there's one other. But that leads to my question, which is, was there any testimony or any evidence presented to the commissioner who issued the order of protection regarding danger to the child that the father may pose? Because in some cases, a spouse may present a danger to the other spouse, but not necessarily to the children. Don't you agree an independent determination has to be made?
I certainly agree. And that leads us to the court's findings with respect to ARS 25-403.03A. So when the court sees that there's a history of significant domestic violence and that kids had been exposed to that, and I say S and E, and so those were the children, the female children of Ms. Brumley, and then there's also W, who is Mr. Brumley's own son. All had been exposed to serious domestic violence, and I would like to reiterate some of those acts. Some of them were just upon Mrs. Brumley without the children, the time that they were in the vehicle and they had an argument, I believe, as well about pornography, and Mr. Brumley stopped the vehicle short. Mrs. Brumley went to get out. Mr. Brumley put it in reverse, knocked her down with a vehicle, which is in counsel's, in my eyes, is an act of significant domestic violence because
the court didn't make that finding. They didn't make a finding of significant domestic violence. They found an act of domestic violence under 403.03D. And I believe in your briefing you're saying that the court erred as a matter of law in not finding that it was significant domestic violence, Mr. Blumberg?
Yes, Your Honor, that is an erroneous finding for the reason that the 25403.03A alludes to 3601, which includes 131201A. 3, but an act that places a person in reasonable apprehension of harm, but in this case, grievous bodily harm by using a deadly weapon or dangerous instrument, to wit, a car. So she was frightened by being knocked down by the car door. She had been led to believe that she couldn't trust Mr. Brumley by his conduct. This
evidence, what you're speaking of, that was presented to Judge Driggs, correct?
Yes, it was.
All right, so he considered it. He just didn't maybe find it, in his opinion, to be that compelling to make the finding of a significant history of domestic violence.
And perhaps he did not, but that's why we're here, because we're claiming that he abused his discretion. He abused his discretion in not taking note of a recorded history. So Mr. Brumley's actions with Shannon Brumley
Well, again, I come back to the question, that evidence was presented to the trial judge below.
Yes.
So he must have considered it. He just didn't. It seems to me from the record he just didn't give it the import that you wanted him to place on it.
That would be correct, Judge Bean. So between that and the strict rules of evidence were not adopted, so they wouldn't apply to this case. So when you have a pleading, though, that alleges serious domestic violence in it, then it's followed by the girlfriend, Ms. Martinez, who claims that Mr. Brumley came to her house and threatened to kill her. And Mr. Brumley tried to downplay it, of course, and said, no, it was a gentle, I'm going to kill you. And threw rocks at her door. The trial judge should have given this more grave consideration than he did.
But okay, that
Only
begs the
because
question
of the
to me
history,
that begs the question. Then I believe you're asking us by that statement. You're asking us to reweigh the evidence, and that we clearly can't do. I think you would even agree, and I think you said it in your brief, and I appreciate your candor. But we can't reweigh the evidence.
Only if the record is devoid of, if it's made up of clearly erroneous conclusions by the trial judge, can you reverse. And that's what Mrs. Brumley is claiming, that these findings are clearly erroneous based upon a history that is inclusive, that for 25403.03A purposes, that the judge would never have gotten to his lengthy dissertation about 25403.03D and determining whether or not Mr. Brumley had appropriately rebutted a presumption. He would never have gotten to that with a significant history of domestic violence. I don't think we're expecting that people have to have arms cut off or be beaten or be physically violated in order to put together a history. Judge Bean, if this had not occurred over a decade of time, then Mr. Brumley probably would not be considered falling into the category of 403.03a. He would have probably been subject to a rebuttable presumption, which
Over a decade, meaning including the conviction with the ex.
the conviction was with the girlfriend, I think, and
It wasn't a conviction, it was just a complaint, I believe.
Well, Mr. Brumley admitted he had been convicted. He admitted it to Barb Kiffmeyer, he admitted it to Judge Boak, and he admitted it in the trial. An admission...
Okay, but my question is, when you say over a decade of domestic violence, you're starting from the incident which did not involve Ms. Brumley.
I most certainly am. You're so correct, because if the trial judge doesn't consider the pattern, then there would be no import to 25403A, because I don't think a person would last that long, either the assailant or the receiver of the domestic violence. So, for example, if it was so severe that the perpetrator would end up in prison.
Okay, let me stop you there for a second,
Sure.
because I think we've had a fair amount of discussion, and rightfully so, with regards to the dynamic between the Brumleys, husband and wife. But let's go back to the issue of JB, because that's really the crux of the case and why we're here. Multiple professionals were involved in this case, and of those, did anyone say that Mr. Brumley presented a danger to JV?
Only indirectly, and this is for a court to infer through S and E and W. S, E, and W had all suffered at the hands of Mr. Brumley as set forth for you by Barb Kiffmeyer, saying that I think it was E complained to Barb Kiffmeyer, I can't talk to my real dad about this because I'm in fear of what Mr. Brumley will do to me if I expose that. So
Now,
the child...
There was a fair amount of animosity, though, between those stepchildren and Mr. Brumley, to be fair.
Oh, most certainly created by Mr. Brumley, yes.
Well, there was a
Perhaps.
fair amount of animosity between them, the children of Mrs. Brumley and Mr. Brumley. So isn't it for the trial court to make a credibility determination as to that evidence that was presented and still be able to decide that while there may have been conflict between the stepchildren and Mr. Brumley, that does not trickle down to the relationship between Mr. Brumley and JB?
Judge Cruz, E broke into tears when relating the fear imparted by Mr. Brumley to the children and related it to Barb Kiffmeyer.
Right, but that's equal to you saying, Judge Cruz, this child was believable.
And what you're saying is this is all equal to, let's give the man another chance.
No, not at all. What I'm saying is, wasn't it for the judge to determine, a lot of people cry in court. All three of us were Superior Court judges. A lot of people cry.
Of course.
So, and it's up to the judge to determine, is this credible, or is part of this testimony credible and perhaps part is not, or to what degree does this experience, even if I believe this child and it's emotional for the child, and certainly you would agree that a child coming into court would be emotional just by virtue of being in the middle of a dispute like this. So, but isn't it the Superior Court's prerogative to say, okay, I believe this child is upset and I believe this child has certain fears, but based on the information that I'm receiving here and also the information that I have from all of the other people who are involved in evaluating Mr. Brumley, I still believe that the issues are more related to these dynamics and not necessarily affecting JB.
He could come to that conclusion, but it would be erroneously based. And I say that for the following reason. Mr. Brumley came armed with a one-page report from a psychologist who said, oh, listen, I think the guy's sitting on solid ground and he doesn't have any problems. He didn't play the recordings for him, and he didn't discuss the findings of Barb Kiffmeyer, who spent detailed time with the children. The judge didn't spend any time with the children, so the judge can only go based off of what Barb Kiffmeyer told him in Barb Kiffmeyer's report, which was made an exhibit at trial.
But didn't Ms. Kiffmeyer suggest that father being reintroduced to JB's life through supervised visits, and that father transitioned to unsupervised parenting time once he and JB had been reunited?
Yes, Judge, and I wholeheartedly agree over time. But that's not respondent appellant's choice, which brings me to attorney's fees. If respondent appellant had said, "Oh, husband, why don't we come to an agreement and go ahead, you can have unsupervised time." Something happens to child. You know, there was an event, by the way, that was related and made a part of the record. It might have been in front of Judge Polk, where father was so busy doing porn that he ignored the child. And so, regardless of that, Judge, the point being, Mrs. Brumley would have been negligent or perhaps reckless in entering into an agreement before a court order and saying, "Go ahead, husband, have unfettered, unsupervised visitation with your son, and we won't worry about your past history." She would be the first person we being the judiciary, would come after if something happened under the statute cited in my brief, which is Title 8, which it makes it a person could have their parental rights terminated or an action brought against them by DCS if they were negligent, if they knew about domestic violence involving or in front of their children. They have a duty to protect their children. So the only choice Ms. Brumley had was to go to court and say, if it's your Honor's decision, fine. But we weren't objecting to a pattern where he would go to supervised visitation. And by the way, he had some supervised visits and did okay. But it's not Mrs. Brumley's decision to make. Mrs. Brumley had to follow a finding of two magistrates that there was serious domestic violence, one by the commissioner, one by Judge Polk, who was the judge prior to the trial judge. And I don't think Mrs. Brumley had the capacity to make that type of decision in face of those two rulings against Mr. Brumley. She could be looked at, she could be have something happen to her from the legal system as well. So to assess attorney's fees against her is absolutely an abuse of discretion. She had to contest this,
but she did that in the face, counsel, in the face of, I think, Dr. Cristiano, Ms. Kiffmeyer's supplemental recommendation. I can't remember if it was Mr. Jones. As Judge Cruz alluded to, all of the experts in this case said that father was highly motivated to be an excellent father. You know, through improving his skills, his relationship with his children should be encouraged. And yet your client, I think on cross-examination, said that she couldn't foresee in the foreseeable future any time that father would have unsupervised parenting time with his child. So I believe that was Judge Driggs' basis for the unreasonable position she took in awarding the attorney's fee. So walk me through that, why that was error.
Judge Bean, she said, I think she used God, I hope to God that someday it is appropriate. So I don't think she said this is never going to happen. There are mothers who could say this is never going to happen. This wasn't such a case. And Barb Kiffmeyer didn't make a supplemental report. She should have, and she should have interviewed the parties and the children a second time for trial, but she did not. And she apologized about that at trial, but I brought her through all of the past acts that were related in our briefs, and Barb Kiffmeyer agreed that gave her grave concern. The judge didn't want her opinion as to whether or not that amounted to significant domestic violence. But I don't think there could be any other view, and that's why we're here.
If we were to accept everything you said about the acts, that you believe them to be significant domestic violence, that still goes back to our review. And Judge Driggs made a decision about what he believed the acts consisted of and how he thought that bore on the determination that he made. You're asking us to find he abused his discretion. But what I've heard from you is all having to do with credibility issues. You just said it would have been nice if we would have had a supplemental report, but Judge Driggs didn't have a supplemental report. So how do you get us from judging credibility of the witnesses, which we will not do, reweighing the evidence, which we cannot do, to finding an abuse of discretion? That's what I'm struggling with, Mr. Bloomberg.
Judge, thank you. We defer to the trial court, do we not, in judging credibility? And I think if the decision of the trial court is erroneously based and is not based on testimony in the record, then it's subject to being overturned. And it would be overturned because of the substantial history laid out by Mr. Brumley, not because of any testimony by Mrs. Brumley. These acts were admitted to by Mr. Brumley, and he claimed that he was a victim in every such act. You know, I'm a victim for this, I'm a victim for that, but however, I'm much better now. It's not for Mrs. Brumley to decide. And so in spite of our request that you reverse the case and remand for a new trial, there's no way Mrs. Brumley could have been charged for attorney's fees because she couldn't be taking an unreasonable position by coming to court. It's virtually impossible. So I leave it to you, Your Honors. Thank you very much for being patient with me.
Thank you.
Morning. May it please the court. My name is Daniel Riley on behalf of the appellee, Kenneth Brumley, in this case. I think from the questions that were asked, the court understands that this is an attempt to request that the court reweigh the evidence, but it's being laundered as a request to reverse as an abuse of the court's discretion. The trial court heard substantial evidence, considered each of the necessary statutory factors, entered 11 pages of findings concerning those factors, and based upon those findings determined it was in the child's best interest that the parties exercise joint decision-making and equal parenting time. I don't know that a rebuttal is necessary, but if you have questions, I'm certainly happy to answer those.
You would agree with me, given the circumstance between the two parties, that joint decision-making would require cooperation that the parties up to this point have been unable to actually effectuate?
I would agree with that. I don't know that Judge Driggs necessarily agreed with that, and he entered substantial findings and determined it was in the best interest of the child that the parties should exercise joint decision-making. It might not be the outcome that I would have found under the facts. It might not be the outcome you would have found under the facts, but it was within the judge's discretion to enter that order.
Talking about the judge's discretion, isn't there some amount of review of the evidence that we do to determine whether the weighing that was done at the Superior Court was or was not abuse of discretion? For example, using extreme cases to really clarify, let's say that there was evidence that Mr. Brumley had, I don't know, broken the child's arm or, been physically abusive, and the judge at the Superior Court says, I think that was in the past, and he's telling me that he's not going to do it again, so it's fine. Of course, that's an extreme case, but don't we look at the Superior Court's fact-finding process and say, well, given the evidence, it was an abuse of discretion to find the way the Superior Court did?
Yes, and the standard you would apply is whether the ruling of the trial court was clearly erroneous based upon the facts. Here, that conclusion can't be reached because the trial court entered a ruling that was consistent with the opinions of 4 separate experts who had between them 2 master's degrees, 2 doctorates. It wasn't an abuse of discretion for the court to give greater weight to the opinions of those experts versus the lay opinion of Mother's testimony.
Well, but didn't Mother witness those acts firsthand? She
did, and she described those to Barb Kiffmeyer, and Barb Kiffmeyer considered those, and she entered a supplemental report after Dr. Cristiano conducted his examination, and her opinion was that father should be given a period of supervised parenting time to reestablish himself in the child's life. And that's what happened between the time of the temporary orders hearing and the final trial. There were 7 months there where he had supervised parenting time, and he complied with all the other orders that were entered at the temporary orders hearing. And those orders were entered consistent with the recommendations of Barb Kiffmeyer. More specifically, that father continue with counseling, that he have supervised parenting time, that he attend an age-appropriate parenting class. So by the time of trial, he had complied with all the recommendations of the experts in this case.
Now, let's turn to attorney's fees. Mother raises the issue of her concerns regarding father's abusive conduct, and she was in a protective role, which is a role that she should take, and the law requires of her. So, why was the award of attorney's fees against Ms. Brumley justified?
The court weighs two factors in determining whether to award fees. They consider the financial resources of both parties. In this case, her income is significantly higher, about $25,000 more per year is what she earns. And the court also considers the reasonableness of both parties. At trial, she testified that she wanted supervised parenting time to continue into an indefinite period in the future. And this was despite the recommendations of all the behavioral health professionals. Even Barb Kiffmeyer, who recommended supervised parenting time, recommended it on a temporary basis simply to reestablish father in the child's life. Not because of safety concerns, but because he'd been out of the child's life since the child was 1 month old. A year had elapsed at that point where he had spent no time with the child because the order of protection was in place. When you have 4 behavioral health experts that are saying, we don't agree that father should have supervised parenting time, but a parent is coming to court and demanding indeterminate supervised parenting time until some point in the future, knowing that a parent can't petition to modify parenting time for at least a year after a parenting order has been entered. So at a minimum, that would be supervised parenting time for another full year. I do think the court had discretion to determine that was not a reasonable position.
Given the history between the parties and given the admissions made by your client to engaging in acts of domestic violence, given all of that, how is it unreasonable for a mother to say, I want supervised visitation to ensure my child is safe? Had there been no history of domestic violence, had there been nothing that had gone on to put any of the children at risk or in fear, wouldn't we have a different situation? That I can see would be unreasonable. But here we have a series of acts and a lot of information from the older children that they were frightened of this man. How is that unreasonable?
If she had proposed a step-up parenting plan that would include supervised parenting time for a period of time that graduated into unsupervised parenting time, then under that circumstance, I think that might have been a clearly erroneous holding. But in this case, she was demanding supervised parenting time until some undeterminate point in the future, again, despite the recommendations of the 4 behavioral health professionals who were involved.
With the understanding that within 12 months, Dad can try and change that. I mean, indeterminate could be a year, 10 years, etc. So all parties were aware that that could be modified within 12 months, after 12 months, or a substantial change in circumstances, correct?
That is correct.
So when she says indeterminate, when you use the word indeterminate, there are some stopgap measures between now and forever.
Correct. She would be essentially placing the ball in father's court to file a petition to modify 1 year down the road if she was granted a supervised parenting time into some indeterminate point in the future.
So how is that unreasonable?
Because, again, it was against the recommendations of the behavioral health professionals who were involved in the case.
So,
and I apologize.
No, I'm just trying to get my mind around what you're saying. So if a behavioral health specialist with a degree says this is what should happen, it's unreasonable for a parent to disagree with them?
I think when there are 4 behavioral health professionals with the unanimous opinion that is contrary to what the parent is asking for, under that circumstance, I don't believe it's an abuse of the trial court's discretion to find that the parent is taking an unreasonable position when it's contrary to the unanimous opinions of 4 separate behavioral health experts.
Moreover, Mr. Riley, was there any any credible evidence to show that JB's physical, mental health would be endangered or significantly impaired if father had a graduated, supervised, and then unsupervised parenting time with JB?
No, Your Honor. All the allegations against father predated the child's birth, and mother reached back 14 years and compressed 14 years of behavior into a 2-hour trial. I don't think any of us would look great if we took 14 years of our worst decisions over that course of time and compress it into a 2-hour trial. None of the allegations occurred while the child
Because a lot of the allegations, to be completely candid, were against the children, the mother's children that she didn't have with father in this case, and clearly he did not, and could not seek parenting time with them. This was specifically, as to Judge Cruz's point earlier on, this is specific as to JB, correct?
Correct. If there are no further questions, I have nothing further to add.
All right, thank you.
Thank you.
Thank you, counsel.
Counsel, we thank you for the vigorous argument. We do appreciate your good preparation. This matter is now under advisement and will issue a decision in due course. We're going to take a recess to prepare the courtroom for the next oral argument.